The Arbitration and Conciliation Act 1996 extend to selected state of India, the whole of India, the whole of India. Which of the following is mandatory? Requirements for an arbitration agreement to be valid. It must be signed before notary. It must be in writing, yes. It must be approved by a court. It must include three arbitrators. So the answer is B. It must be in writing. In arbitration, what is meant by the principle competence? The arbitrators have the power to decide their own jurisdiction, yes. The arbitrator cannot decide this jurisdiction without court approval, no. Only the High Court can decide, no. Competence is determined by the parties' mutual agreement. So the answer is A. Which one of the following which of the following cannot be referred to arbitration? Commercial contract disputes, no. Intellectual property disputes, no. Criminal matters, it cannot be arbitrations. Construction contract disputes. So the answer is C. Which of the following cannot be referred? In case of international commercial arbitration, who has the power? International commercial arbitration, who has the power to appoint an arbitrator if party fails to agree? The Supreme Court of India, the District Court, the Lok Adalat, the Consumer Forum. So the answer is A, the Supreme Court. Under the Arbitration and Conciliation Act 1996, which of the following is not a ground for setting aside an arbitral award? The arbitrator's decisions was incorrect on facts. The arbitration's agreement was invalid. The arbitrators was biased. The award violates public policy. So which of the following is not? So the answer should be A. Which of the following statement about the seat of arbitration is correct? The seat determines the governing procedural law. The seat is irrelevant as long as the arbitrators is appointed. The seat must be the location of the disputed transactions. The seat is the location where arbitration hearings are held. So the answer is A. The seat determines the governing procedural law. The primary function of an arbitral tribunal is mediate between disputing parties, no. Decide dispute based on the evidence and law, yes. Represent one of the party in court, no. Negotiate a settlement, no. So the answer is B. In arbitration, the principle of separability refers to the arbitration clause being independent from the main contract, yes. The arbitrator's power to separate issue for ruling, no. The needs to separate domestic and international arbitration, no. The requirement to have multiple arbitrators for complex cases, no. So the answer is A. The arbitration clause being independent from the main contracts. When does an arbitral proceedings commence under the Arbitration and Conciliation Act 1996? When an arbitrator is appointed, no. When the dispute arises, no. When the request for arbitration is received by the respondent. So the answer is C. If an arbitrator consult a third party regarding the case without informing the disputing party, it amounts to procedural flexibility, arbitrators' discretions, misconduct, justified action for dispute resolution. So the answer is C. Which of the following is a feature of an arbitral award? It is always subject to appeal in the Supreme Court. No, it must be in writing and signed by the arbitrator. It is valid only if approved by High Court. It must be always includes financial compensation. So the answer will be if one party fails. If one party fails to participate in arbitration proceeding without valid reason, the arbitrators may terminate the arbitrations, no, proceed ex parte and pass an award, seek permission from the court to continue, no, appoint a new arbitrator. So the answer is B. Under Section 21 of the Act, arbitration, Section 21 of the Act, arbitrations proceedings commence when the arbitrators agrees to take up the case, no, the party agrees to seat of arbitration, no, a party makes a request for arbitrations and it is received by the respondent. So the answer is C. The principle of minimal judicial intervention in arbitration is emphasized in Section 5 of the Arbitration and Conciliation Act 1996, yes. Section 7, no. Article 21, no. So the answer is A. Which of the following is true regarding the enforcement of foreign arbitral award in India? It must be registered in an Indian court before enforcement. No, it is automatically enforced once declared by the arbitrators. No, it must comply with the New York Conventions or Geneva Conventions. It cannot be enforced in India. So the answer is C. What is the primary primary role of an arbitrator in an arbitration proceedings? To negotiate a compromise between the parties, to represent the interest of a stronger party, no, to educate the dispute based on law and evidence. So the answer is C. So the primary role of an arbitrator in an arbitration proceeding is to adjudicate the dispute based on law and evidence. 18. If an arbitral tribunal determines that an arbitration agreement is invalid, if tribunals determines that agreement is invalid, it result in the entire contract being nullified, no, the arbitration proceed being terminated, yes. The tribunal proceeding with a court's approval, no, dispute being automatically referred to conciliation, no. So the answer is B. If a party objects to the jurisdiction of arbitral tribunal, it must do so before the first hearing, any time before the final award is passed, only in court of law after the arbitration proceedings. If a party objects to the jurisdiction, it must do so before the first hearing. So the answer is A. When deciding the place of arbitration in the absence of an agreement, the arbitrator should consider the arbitrator's convenience, the neutrality and impartiality of the locations, yes, proximity to the one of the parties, no, the preference of the party initiating arbitration, no. So the answer is B. In ad hoc arbitration, which of the following is true? It always requires a three members. No, procedural rules are set by an institution. No, it is generally more cost effective than institutional arbitration. See, the answer is if an arbitrator selects a place of arbitration that has no significant connection with the contracts or parties, how should the award be classified? International award, foreign award, domestic award, interim award. So the answer is C, domestic award. A dispute involving professional fees is taken to the court and one party requests arbitration, when can the court refer the case to arbitration? The courts cannot refers it to arbitration. The court must always refer it if requested. The courts may refer it only if arbitration agreement is valid and enforceable. Once in court, it cannot be referred to arbitration. The answer is a foreign award was given after the Arbitration and Conciliation Act 1996 came into effect, but the arbitration started before its commencement. Under uh, which law should be award be enforced? Under which law? Arbitration and Conciliation Act 1996. Yes, the law in the effect at the time of arbitration began. No, the law in effect when dispute was referred to arbitration, foreign arbitration law. So the answer is A. A lease agreement. A lease agreement states that rent increases if a gambling house operates on the premise. The dispute is resolved through arbitration and submitted for enforcement. What is correct legal position? The award is enforceable. No, the award is not enforceable as the gambling provision is illegal. Arbitration award is always enforceable regardless of legality. No, the court has discretion to enforce or reject the award. No, so the answer is B. If a WhatsApp message includes a clause stating that disputes will be referred to arbitration and order is fulfilled, is there a valid arbitration agreement? No, there is no arbitration agreement. No, mentioning it on WhatsApp does not constitute an arbitration agreement. Yes, it is considered a valid arbitration agreement. No, no a formal acceptance is required. So WhatsApp message includes a clause. So yes, it is considered as valid arbitration agreement. A service agreement initially include A service agreement initially included an arbitration clause. When it was renewed, the clause was not explicitly added. Does the arbitration agreement still apply? No, it ended with original agreement. Yes, once added, it always continue. Yes, renewal does not require adding the clause again. No, but the renewal agreement has the same effect as the original was. So a service agreement initially included an arbitration clause. When it was renewed, the clause was not explicitly added. Does the arbitration agreement still apply? No, it ended with the original agreement. It does not apply. A partner retires from firm and files a claim for his shares of capital and profits. A partner retires and claim share of capital and profit. This constitute a dispute. Yes, filing a claim indicate a dispute. No, mere filing of a claim is not dispute. No, it depends on the firm creditors. Yes, it can be referred to arbitration. So claiming a share of capital and profits does not merely constitute a dispute. So answer should be B. An arbitrator consult a client about a case without informing the disputing parties. When reported to the court, he argues it was for resolving the dispute. What is the correct legal position? The arbitrator's argument is valid. The arbitrator is guilty of misconduct. The parties will decide if it misconducted. The court will decide if it is misconducted. So an arbitrator consult a client about a case without informing the disputing parties. When reported to the court, he argues it was for resolving the dispute. What is the correct legal position? He argued it was resolving for the dispute. The arbitrator is guilty for of being misconduct. So the answer is B. A contract includes an arbitration clause, but does not specify the place of arbitration. When deciding the location for domestic arbitration, what should be considered? The arbitrator's convenience, the party initiating arbitrations, a neutral and impartial location, proximity to party. So answer is C. All the answers should be D. However, it contradict C and D, so you can take it as answer as C as well and D as well. So my preference would be C. If a supplier increases the price of goods, if supplier increases the price of goods and buyer requests conciliations, can if a supplier increases the price of goods and buyer requests conciliation, can conciliation proceed without the supplier's consent? So no, conciliation requires mutual consent. So it cannot be. Yes, conciliation can proceed without consent. No, no conciliation requires mutual consent. Yes. So the answer is B. Yes, but the outcome is binding. No, conciliation does not allow party autonomy. So the answer is B. Two business partners have a pricing dispute and agree to conciliation. When does the conciliation process begins? When one partner sent a written invitations, no. When the other partner accept the invitation in writing. When partner reject the invitation, when both partners verbally agree. So the answer is B. In a conciliation dispute, one party suggests a single conciliator, but the other party propose multiple conciliator. Which statement is incorrect? With one conciliator, both party must agree on the person. No. With two conciliator, each party appoints one. With three conciliator, each party appoints one, and the two conciliators choose the third. No. With three conciliator, each party appoints one. Yes, and they jointly decide the presiding conciliator. So the answer should be regarding the conciliation process. Which statement is true? It starts as soon as the invitation is sent. No, it can proceed even if the invitation is rejected. No, the invited party must respond within 30 days or a specified time frame for the process to begin. Yes, if no response is received, the process can proceed without consent. No, so the answer is C. What is the conciliator's role in obtaining a written statement? The conciliator cannot request a written statement. The written statements are required but not shared between parties. No, written statement and evidence can be requested and must be shared. So the answer is C. What does Lok Adalat means? Session court, local court, district court, people court. So the answer is D. People courts. Panchayat is a form of arbitration, conciliation, mediations, all of the above, all of the above. In a vehicle collusion dispute, in a vehicle collision dispute refer to a Lok Adalat. What is primary objective? To determine criminal liability and punishment? No. To impose a binding decision? No. To facilitate a voluntary settlement? Yes. To prioritize financial compensation? No. So the answer is C. In a business dispute where suppliers delay caused losses, how should the conciliator address transportation issue? Ignore the supplier's regions and focus on the buyer's losses. No. Investigate transportation issue to determine fault. No. Encourage the supplier to take full responsibility. no, explores solutions and compromise to prevent future delays. So the answer should be D. In an arbitration dispute over construction quality and payment, how does the arbitrators ensure impartiality? By openly expressing biases? No. By maintaining a transparent and fair decision making process. Maintaining a transparent and fair decision making process. By favoring the party? No. By disregarding evidence? No. So the answer should be. In the context of arbitration, what does the term foreign award means? An award passed by an Indian arbitrators but executed outside India. No. An award passed in foreign country and enforceable in India under the Arbitration and Conciliation Act 1996. An award made in India, no, any arbitral award passed in an international commercial arbitration, no. So the answer is B. Which of the following is a key distinction between domestics and international commercial arbitration under Indian law? The nationality of the arbitrators, the place where arbitration takes place, no, the legal system governing the arbitration agreement, no, whether at least one party is a foreign entity. So the answer would be D. A foreign award under the New York Convention can be enforced to India only if the award is final and binding in the country where it was made. Yes, the party mutually agrees to its enforcement. The arbitration was conducted by a recognition institution. The High Court grants special permission. A foreign award under the New York Convention can be enforced in India only if the award is final and binding in the country where it was made. So the answer is A. Which of the following cannot be a valid reason for refusing enforcement of a foreign arbitral award? Under Section 48, the award was induced by fraud. The subject matter of the dispute is not arbitrable under Indian law. The award contradicts a party's business policy. The award violates public policy of India. The award contradicts a party's business policy. So the answer should be C. Under the Arbitration and Conciliation Act 1996, which of the following is not a type of arbitration? Ad hoc arbitrations, no. Institutional arbitration, no. Commercial arbitration, yes. Statutory arbitration, no. So which is not type of arbitration? So the answer is C. Which of the following statement is true regarding institutional arbitrations? The party manage the arbitrations process on their own. No. It follow procedural rules set by the arbitration institution. Yes. It generally less structured. No. It does not require adherence to any. So the answer is B. In an international commercial arbitrations, if the arbitration agreement does not specify the governing law, how it is determined? By mutual agreement after the dispute arises? No. By the law of the country where the award is enforced? No. By the tribunal based on the circumstances of the case? Yes. By default, Indian law applies? No. So the answer should be C. Fast track arbitration under Section 29B is characterized by mandatory appointment of 3 members tribunals, no. A time bound resolution process usually within 6 months. Yes. Conducting hearing in multiple jurisdictions, the requirement of prior approval from the Supreme Court. So the answer should be B. A time bound resolution process usually within 6 months. In ad hoc arbitration, the selection of arbitrator is deciding by the arbitral institution done as per the rule of the High Court based on the mutual agreement of the parties determined by the Supreme Court of India. So the answer should be C. Under the New York Convention, a foreign arbitral award can be refused informants enforcement if it was made in a country that is not a signatory to the convention. The arbitration proceedings were conducted online. The arbitrator was not an Indian citizen. The losing party does not accept the decision. So the answer should be A. It was made in a country that is not a signatory to the convention. What is the significance of Section 45? It allows the court the power to stay domestic arbitration. No, it mandates enforcement of all foreign awards. No, it allows court to refer party to arbitration unless the award is void or inoperative. It permits court to alter the terms of an arbitral award. So the answer should be C. For foreign arbitral award is deemed to decree of the court under which section? 46, 49, 50, 52. So the answer is 49. B. The Geneva Convention on Arbitration Award applies to dispute involving only government entities. No, award made before the New York Convention came into effect. Yes, arbitration cases caused by English law. No, all foreign awards enforced in India. No, so the answer is B. What is the primary role of arbitral tribunals? To negotiate a settlement between the parties, no, to assist in mediation before issuing an award, no, to adjudicate disputes based on law and evidence. So the answer is C. What of the following is the key features of fast track arbitration? No oral hearings are allowed unless necessary. The arbitrations must be completed within 3 months. No, a panel of at least three arbitrators is mandatory. No, the award can only be enforced through the Supreme Court. Which of the following is key feature of fast track arbitration? So the answer is A. No oral hearings are allowed unless necessary. If a foreign awards is challenged in the country where it was made, what is the effect on enforcement in India? It automatically become unenforceable in India. No. Indian courts may refuse enforcement or adjourn the proceedings. Yes. The award is enforced only if both party agrees. No. Indian court must enforce the award. No. So the answer is B. Which of the following statement regarding an arbitral award is incorrect? It must be in writing and signed by the arbitrators. No. It is binding on the party unless set aside by a court. It can be appealed on the ground of factual errors. It may be refused enforcement if it is contrary to the public policy. So, which is incorrect? Answer is C. The key difference between statutory arbitration and contractual arbitration. Statutory arbitration is optional while contractual arbitration is mandatory. Contractual arbitration is mandated by law, whereas statutory arbitration arises from mutual agreement. No. Statutory arbitration is imposed by law, yes, while contractual arbitration is based on party agreement. So the answer should be C. If an arbitral tribunal is composed in violation of the arbitration agreement, what can be affected party do? If tribunal is composed in violations, request the Supreme Court to change the tribunals. No. Proceed the arbitration and challenge the award later. Yes. Challenge the compositions before tribunal itself. No. Immediately terminate the arbitration. No. So the answer should be B. What happens if the arbitrators fails to disclose any conflict of interest before the proceeding? The award is automatically invalid. No, the parties must accept the award if already issued. No, the party challenging the arbitrators must prove bias. The arbitrators must be replaced immediately. So the answer would be C.